Hello everyone. In this video we will try to solve the previous question paper of AIB, that is All India Bar Examination, AIB 17, and I have already solved 50 question of this question paper, and right now we will continue from question number 50. Hmm. So basically the first question says the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be options that we have: option 2, option B, option B 3, option C 4, and option D 5. Now in this question, basically what is missing, or what is the error that we can see, it's mentioned as Article 143, but the thing is Article 143 talks about suggestion of Supreme Court to the president, and whether the suggestion is, and whether the suggestion to be considered by the president or not. So that is section 143, and here by the language we can understand it's misprint, and it should be Article 145 clause 3. So in place of this thing will come, because in this section it is the language. So the language we will see in this section, and 143 basically talks about the consideration of president while taking the advice of honorable Supreme Court. So now cut this and put this, and then we will read this section one more time. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution for the purpose of hearing any reference under Article 145 shall Article 145 shall be option D, that is 5. So the right option is option D, that is 5 judges. Now question number 51. According to the Article 300A of the Constitution of India, no dash shall be deprived his property save by authority of law. Option we have person, citizen, foreigner, and Indian. If you will see the language of Article 300A, you will see after no there is a word person, and in many Supreme Court judgments we will see that Article 300A doesn't talk about the right of a citizen, but it talks about exhaustively for each and every person. Like the person can be Indian, foreigner, or citizen, for all of this. So here it's mentioned person. So the right option is option A, that is person. It is not limited with the Indian or foreigner. It's overall talking about the person. So the right option is option A, that is person. Now question number 52. Which of the following is not law according to Article 13 of Indian Constitution? Option that we have: rule, bylaws, custom or usage. D, none of these. The right answer is none of these. In this question basically it's saying the thing that is not law according to Article 13. But if we will read Article 13, it's clearly mentioned that rule is law, bylaws are law, and custom or usage are also somewhere law. Where court accept those customs, so those are law. So its right option is option D, that is none of these. None of these. Following is not law, none of these. Question number 53. Which of the following schedule deals with union list, state list, and concurrent list of Constitution of India? The option we have Schedule 7, Schedule 10, Schedule 11, and Schedule 12. The right option is option A, that is Schedule 7. So in Schedule 7, we will see three type of a list, that is a state list, central list, and concurrent list. So the right option of question number 53 is option A, that is Schedule 7. Now, question number 54 says the title of the Constitution of India is laid down in dash in Article 393. In Article 1, we will see that short title and name and the name and its territory in Article 1. In Article 5, we will see the we will see the concept of citizenship, and Article 90 is omitted. It has been omitted in 1950 only. 1950. It was basically temporary article, so it has been omitted that time only. So Article 393 talks about the title of Constitution, that is saying that the uh, this bare act will be known as the Constitution of India. So that thing we will see in Article 393. Now, question number 55. Constitutional provision of fundamental rights are given under which part of Constitution of India? Obviously, part 3. Its right answer is option C, part 3. Question number 56. Provision for right of private defense given between dash of IPC. Option A, section 74 to 84. Option B, section 1996 to 106. Option C, section 107 to 120. And option D, 141 to 160. The right option is option B, that is section 96 to 106. So the right of private defense we will see from section 96 to 106 in IPC. In IPC. Next question number 57. The consent is not a valid consent under section 90 of IPC. Options we have: if given under fear of injury or misconception of fact. Option B, if given by person of unsound mind. Option C, if given by child below 12 years of age. Option D, all of these. So this is applicable, this is applicable, this is applicable. So for that we can go with option D, that is all of these. Okay, so according to Article 19, any person who falls in this category and give his consent will not be called as given the consent genuinely, authentically. So the right, so whether the it doesn't matter whether the person has given the his consent, if he fall in this category, whether the person is 12, under the 12, below the 12 years of age, whether the person is insane or uh, unsound minded, or whether the person has given the consent under the fear of injury or misconception of fact. So it's irrelevant whether the person has given the consent, it doesn't matter. So the right option is option D. Question number 58. Question number 58. Causing of death of child in the mother's womb is not homicide as provided under. Is not homicide as provided under. Option that we have explanation 3 to section 300, that is section 300. Option B explanation 3 to section 299. Option C explanation 3 to section 301, and option D explanation 3 to section 302. The right option is option B. Should I stop reading the unnecessary options? Should I go with the direct option? I should do that. I should try that. So the right option is option B. That is explanation 3 to section 299. Okay. So basically, it's not homicide. We have a different category like a miscarriage. So we can go with that, but not. We will not count it as a culpable homicide or murder. We have a different provision especially for this only, called as miscarriage. So we will, and we have the separate section also for the miscarriage. Mm, after after 310 or 320, or somewhere in between 316. So there we will see it, but that will not fall in this in section 299, and it is clearly mentioned in explanation 3 of section 299. Now next question is question number 59. Punishment for defamation under Indian Penal Code is simple imprisonment, as we all know, for a term which may extend to 2 years, which may extend to 2 years, or with fine, or with both. For what? For defamation. If I talk about defamation, the punishment is mentioned in section 500, in section 500, and the definition is mentioned in section 499. The next question is assault or criminal force to women with intent to outrage her modesty under IPC is which kind of offense? The answer is option C, that is cognizable and non-bailable. Before 2013, in CRPC, amendment came in 2013. Before that, the offense was bailable by nature, bailable. So before 2013, if the question would be have asked before 2013, the right option would be option B, that is cognizable and bailable. But when the amendment came, it gave the provision that and they figured it out like it's a serious grievous offense. And while seeing the depthness of that crime, they changed from bailable to non-bailable. So now if any person wants to try or assault or do any criminal force, make any criminal force for, to a woman with intent to outrage her modesty, that kind of punishment will be cognizable and non-bailable. If you don't know the meaning of cognizable, in simple language, we can say very serious, संज्ञेय अपराध, a very serious kind of crime. And नॉन बेलेबल मीन्स कि आपको रिलीज नहीं किया जाएगा, आपको जेल में रखा जाएगा, दैट इज नॉन बेलेबल. एंड बेलेबल मीन्स कि आपको रिलीज कर दिया जाएगा कोई श्योरिटी वगैरह सबमिट करके कि हाँ आप गारंटी देते हैं कि आप इस जगह को छोड़ के नहीं भागेंगे, और वो श्योरिटी रख के आपको रिलीज कर दिया जाएगा. बट नॉन बेलेबल में आपको रिलीज भी नहीं किया जाएगा, और कॉग्निजेबल मीन्स कि आप जो क्राइम है वो सीरियस, काफ़ी सीरियस नेचर का है. नाउ क्वेश्चन नंबर 61. A places men with firearms at the outlet of a building and tells Z that they will fire at Z if Z attempt, where is the cursor, if Z attempts to leave the building. A is guilty of, the right option is option A, wrongful confinement. ठीक है, इसका ऑप्शन सी भी हो सकता था, रॉन्गफुल कन्फाइनमेंट एंड रॉन्गफुल रिस्ट्रेन. बट रॉन्गफुल कन्फाइनमेंट की खासियत क्या है कि इसमें इनबिल्ट रॉन्गफुल रिस्ट्रेन जो है इसमें इनबिल्ट आ जाता है. ठीक है, तो ये यूज़ करने की ज़रूरत नहीं है, क्योंकि रॉन्गफुल कन्फाइनमेंट में ही रॉन्गफुल रिस्ट्रेन भी आ जाता है. तो अगर रॉन्गफुल रिस्ट्रेन ये है तो रॉन्गफुल कन्फाइनमेंट ये है. ठीक है, तो एक ऑप्शन से भी काम चल सकता है, तो वी विल चूज ऑप्शन ए, दैट इज रॉन्गफुल कन्फाइनमेंट। नेक्स्ट क्वेश्चन इज question number 62. The provision of plea bargaining under chapter 21A of CRPC are not applicable if the offense is committed against a child below the age of the option we have 12 years, 14 years, 16 years, and 18 years. And its right option is option B, that is 14 years. I have tried to figure it out, like where pro- I have tried to figure it out, like where it has been obviously mentioned that below the age of 14 years, if the crime is taken place with the child whose age is below the age of 14 years, where that section is basically mentioned, but I failed in that, and I didn't able to find that section. So you have to tell me, like I did a lot of research work, but failed to find out that where it has been mentioned. As far as I have researched, what I got that um, we will we have taken the idea from POXO, the act from POXO, from JJ Act, and from many Supreme Court judgments, and it from JJ Act, from POXO, and from Supreme Court judgment. From this thing, we came to know that if the child's age is under the 14 years or below the 14 years, then the person who made the crime will not be able to take the benefit of plea bargaining under chapter 21A of CRPC. But I still didn't find the accurate place where it has been mentioned, like the age has been mentioned, that the person will not be able to take the advantage of plea bargaining um, if the child is 14 years of age. So specifically I have not found out, able to find that out, but if you, but you can tell me if you know. Question number 63. Under section 82 and 83 of Indian Penal Code, an offence is punishable if it is done by a child. Option that we have below 7 years of age, ठीक है, and offensible if it is done by, an offense is punishable, इसमें पूछा है कि punishable होगा, ठीक है, अगर किसी बच्चे ने किया है तो कब कब पनिशेबल होगा, जबकि जनरल रूल से कहता है कि कोई बच्चा अगर क्राइम करता है तो वो ऑफेंस नहीं माना जाएगा। लेकिन इसमें अपोजिट पूछ रहा है कि कोई बच्चा अगर क्राइम करता है तो कब पनिशेबल माना जाएगा, कब ऑफेंस माना जाएगा। ठीक है, तो ये तो नहीं है। 7 साल के, 7 साल या 7 साल से कम का अगर बच्चा है, वो अगर कोई ऑफेंस करता है तो ऑफेंस नहीं माना जाएगा। जनरल एक्सेप्शन में आता है। ऑप्शन बी इज सेइंग ऑफ above 7 years of age but below 12 years of age having attained sufficient maturity, कि कोई व्यक्ति है, कोई बच्चा है जो 7 साल से बड़ा है और 12 साल से नीचे का है, तो इस एज का अगर कोई बच्चा है, इस एज का कोई बच्चा है और उसने सफिशिएंट मैच्योरिटी जो है वो गेन कर ली है, उसको चीज़ों की समझ है, समझ बूझ है, और ऐसे में वो बच्चा जो है अगर क्राइम करता है तो उसको ऑफेंस माना जाएगा। ठीक है। ऑप्शन सी में क्या कहता है, ऑप्शन सी में जो एज कवर किया गया है 7 to 10 किया गया है, हैविंग सफिशिएंट मैच्योरिटी एंड अंडरस्टैंडिंग। ठीक है, सब कुछ सेम है, बस 7 to 8। अब 7 to 8 ये है, 7 to 12 ये है, तो ये ऑलरेडी इनबिल्ट इसमें आ गया। ठीक है, एक्चुअल में ये है तो ये वाला इसमें इनबिल्ट आ गया। मान लो अगर ये 14 होता तो गलत था, लेकिन अभी 10 है और ये 12 है, तो 7 to 12 ही वैसे प्रोविजन में मेंशन है, तो 10 की आवश्यकता नहीं है यहाँ पर, तो ये भी गलत हो जाएगा। Sometimes I think like I'm very poor teacher, I'm very poor explainer, and I have to work on it. The last option is option D, that above 7 years of age but below 12 years not having attained sufficient maturity. अब इसमें भी above 7 year है and 12 years है, but difference क्या है कि इसमें sufficient maturity उसने gain कर ली थी, इसमें नहीं की है, not gained sufficient maturity. तो ये भी नहीं होगा, ये भी नहीं होगा. Right answer will be option B, that is of above 7 years of age but below 12 years having attained sufficient maturity and understanding. The next question is question number 64. Name two essential conditions of penal liability. The right answer is option C, mens rea and actus reus. Mens rea, what's wrong with it? Mens rea, actus reus. ओके, ये दो चीज रिक्वायर्ड होती है किसी भी एक्ट को ऑफेंस में कन्वर्ट करने के लिए. गिल्टी माइंड एंड रॉन्गफुल एक्ट की उसने अपराध सोचा भी, उसने अपराध किया भी. ओके, सो टू एसेंशियल कंडीशंस ऑफ पीनल लायबिलिटी. Question number 65. Which sections deal with the process to compel appearance under Code of Criminal Procedure 1973? Which section deal with the processes to compel appearance? ठीक है, कि आपको कोर्ट में अपीयर होना ही होगा. तो मैंडेटरी कौन करता है, कौन सा प्रोविजन करता है? सीआरपीसी में सेक्शन 61 टू 90 अगर हम रीड करते हैं, दैट इज ऑप्शन ए. Then we will figure it out, then we will find it out that it's talking about the appearance that is making it mandatory to appear. Question number 66. An offense for which a police officer may arrest a person without warrant is known as option B, that is cognizable of offense. Means संज्ञेय अपराध, means very serious offense. ठीक है, तो उसमें वारंट रिक्वायरमेंट नहीं होती है कि पुलिस जाए कोर्ट के पास और वारंट ले और फिर उस व्यक्ति को अरेस्ट करे, तब तक वो भाग जाएगा. तो ऐसे में वो बहुत ही, अगर उसने कोई हैवी क्राइम किया है, कोई सीरियस क्राइम किया है, तो कॉग्निजेबल ऑफेंस में कोर्ट जो है ये पुलिस जो है विदाउट कोर्ट ऑर्डर जो है या फिर विदाउट वारंट जो है उसको अरेस्ट कर सकता है. यहाँ पर वारंट से मेरा मतलब जो है वही कोर्ट ऑर्डर से है. क्वेश्चन नंबर 67. In a summons trial case instituted on a complaint wherein the summons has been issued to the accused, in a summons trial case instituted on a complaint wherein the summons has been where the summons has been issued to the accused, the non-appearance or death of the complainant shall entail option A, discharge of the accused, option B, acquittal of the accused, option C, either discharge or acquittal depending on the facts and circumstances of the case, option D, none of these. The right option is option B, that is acquittal of the accused. In the summon trial cases instituted on a complaint wherein the summon has been issued, where the summon has been issued to the accused, the non-appearance or death of the complainant shall entail acquittal of the accused. ठीक है, समन ट्रायल केसेस मीन्स उतना सीरियस ऑफेंस नहीं है. उस केस में अगर जो है कंप्लेनेंट जो है या तो कंप्लेनेंट की मृत्यु हो गई, इधर द कंप्लेनेंट हैड डाइड और इधर द कंप्लेनेंट हैड refused to present appear in the court or denied to appear in the court or did not able to did not appear in the court intentionally. In those cases the court will give the acquittal to the accused. The court will grant the acquittal to the accused. Question number 68. Suppose FIR is not registered by the station house officer. What are the options that the complainant has? Complainant can directly approach to the superintendent of police. That's it. Okay, first of all, if the person is not registering FIR, the person can send a letter, make a letter to superintendent of police and make a request to um, order them or forward the message to file the FIR. We can also go to the magistrate by filing a private complaint. So we can do this also. This is not the right option. Both superintendent approach. Uh, this gonna be also like justified, but first of all, we have to go with this approach superintendent of police. If we didn't tried this, then the court will ask like did you did you try to approach to the superintendent of police SP or not? So there gonna be that loophole that in which we can stuck. So first of all, we have to approach to the superintendent of police. Question number 69. Any police officer making any investigation under Section 160 of CRPC cannot require the attendance of a male at a place other than the place of his residence who is, the right option is option C, under the age of 15 years and above the age of 65 years. Like the police officer can't force that person to appear or to make his to give his attendance. Okay, the police officer have to go at that place where the person is living whose age is under the 15 years or over the 65 years, above the 65 years. The next question is question number 70. Section 125 of criminal procedure code is secular in character was observed in which of the following cases? It was held, it was observed in Muhammad Ahmad Khan vs. Sahabanu Begum, that section 125 is secular by nature. Question number 71. Who has the power of summary trial of a case? Options that we have: Chief Judicial Magistrate, option B, Metropolitan Magistrate, option C, any magistrate of first class, especially empowered by the High Court, option D, all of the above. So the right option is option D, that is all of the above. So any of them can try the summary case, the summary trial. Question number 72. Which order of civil procedure code deals with temporary injunction and interlocutory injunction? The right option is option B, that is order 39. Question number 73. A is a tradesman. A is a tradesman in Ahmedabad. B carries on business in Delhi. A in Ahmedabad, B in Delhi. B by his agent in Ahmedabad buys goods of A and requests A to deliver them to the Western Roadways Transport Company. A delivers the goods accordingly in Ahmedabad. A may sue B for the price of the goods. A in Ahmedabad only, option B in Delhi only, option C in either Ahmedabad or Delhi, Option D, anywhere in India. The right option is option C, that is in either Ahmedabad or Delhi. Question number 74. Which of the following section of Civil Procedure Code deals with the concept of res judicata? The right option is option B, that is section 11. Section 10 talks about res sub judice and section 11 talks about res judicata. Section 75. Mr. X, Mr. Y, and Mr. Z are jointly and severally liable for 10,000 under a decree obtained by Mr. A. Mr. Y obtains a decree for 10,000 against Mr. A singly and applies for execution to the court in which the joint decree is being executed. Which of the following option is correct for Mr. A? Its right option is option A, that is Mr. A may treat his joint decree as cross decree under A may treat his joint decree as cross decree under Order 21, Rule 18. Question number 76. A, B, and C are co-partners of joint Hindu family. They jointly execute a mortgage in favor of Y. A files a suit against all of them. Summons is served to C but not to A and B. None of them appears and an ex parte decree is passed against all. A and B apply to set aside the ex parte decree. The decree will be set aside against A, B, and C. A, B, and C, a co-partner of joint family, they jointly execute a mortgage in favor of Y. Y files a suit against all of them. Summon is served to C, but not to A and B. None of them appears. An ex parte decree passed. A decree is passed against all. A and B applied to set aside the A and B applied set aside the ex parte. The decree will be set aside against A, B, and C. ठीक है, तो ए को मिल गया था लेकिन तब भी वो सेटिसाइड हो जाएगा अगर बी और सी के लिए सेटिसाइड हो रहा है तो. Question number 77. If someone lies before the court on affidavit, how it can be tackled by the advocates? If someone lies before the court on affidavit, how it can be tackled by the advocates? Option that we have, perjury application can be filed. Option B, withdraw from the case. Option C, file application to support that. Option D, pay the fine for the same. The right option is option A, perjury application can be filed. I have to learn about this. Like this is very interesting question. If your client has been given a false information on affidavit, how that situation can be dealt by an advocate. So basically, it's saying that an advocate can apply for the perjury application. So if the advocate gonna apply, file and file a perjury application, it gonna work. So I have to see what is perjury application. Now let's see section 78. Proclamation for person absconding shall be published as follows. Proclamation for person absconding shall be published as follow. Its right option, the first one is, it shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. Option second, it shall be affixed, पब्लिकली रेड, उसके बाद अफिक्स पहले सबके सामने पढ़ा, उसके बाद पेस्ट कर दिया. इट शैल बी अफिक्स टू सम कॉन्स्पिशियस पार्ट ऑफ द हाउस और homestead in which such person ordinarily resides or to some conspicuous place of such town or village. Option C, a copy thereof shall be affixed to some conspicuous part of the courthouse. Copy दिया जाएगा. Option 4, the court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. Its right option is option D. all, first, second, third, fourth. It can be done with all with using all these four steps. Question number 79. Which of the following statement is incorrect? Option that we have: first appeal can be on question of fact or law or both. Option B, second appeal can be on substantial question of law only. Option C, second appeal can be on question of fact or law or both. Option D, first appeal may or may not be in the High Court. Second appeal has to be in the High Court. The right option is option C, that is second appeal can be on question of fact or law or both. So this thing is incorrect. Apart from that, everyone is correct. All remaining three option is correct. Incorrect. First appeal can be on question of fact or question of law. Second appeal can be on substantial question of law only. First appeal may or may not be in the High Court. Second appeal has to be in the High Court. The next question is, its right answer is option C. The next question is question number 80. As per order 6, pleading shall mean option A, plaint; option B, written statement; option C, both plaint and written statement; option D, none of these. Right option is option C, that is plaint and written statement, and both will known as pleading jointly. In we will see in order 6 of CPC. Next question is question number 81. Which of the following order deals with death, marriage, and insolvency of parties? The right option is option C, that is order 22. Order 22 deals with death, marriage, and insolvency of parties. Question number 82. The doctrine of res gestae has been discussed in which section of the Evidence Act? The right option is option B, section 6. Res gestae has been discussed in section 6 of Indian Evidence Act. Now it is known as Bharatiya Sakshi Adhiniyam 2023. Question number 83. When the liability of a person who is one of the parties to the suit depends upon the liability of a stranger to the suit, then an admission by the stranger in respect of his liability shall be an admission on the part of that person who is a party to the suit. It has been so provided under which section of the Indian Evidence Act 1872? The option that we have: option A, section 17; option B, section 18; option C, section 19; and option D, section 21. The right option is option C, that is section 19. Question number 84. Judicial evidence means evidence received by courts in proof or disapprove of facts. Judicial evidence received by police officer, home department, tribunal. Right option is option A, that is evidence received by courts in proof or disapprove of facts. So both will be evidence. Whether a fact has been proved or whether a fact has been disproved, both gonna be taken as an evidence. Question number 85. Which of the following is not a document according to the Indian Evidence Act 1872? Options that we have: an inscription on a metal plate or stone, ये है. Option B, a map or a plan, ये भी है. Option C, a caricature, ये भी है. Option D, none of these. इसका राइट आंसर है ऑप्शन डी, दैट इज नन ऑफ दीज. इसमें से पूछ रहा है कि कौन सा ये इनमें से कौन सा डॉक्यूमेंट नहीं है. ये तीनों डॉक्यूमेंट है, तो ऑप्शन डी इज द राइट आंसर. नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 86. Presumptions as to dowry deaths is given under which section? The right option is option B, that is section 113B. Presumption as to dowry deaths is given under which section? Section 113B of Indian Evidence Act. Question number 87. Which of the following is not secondary evidence as per section 63 of Indian Evidence Act 1872? The right option is option D. Copies not certified under section 63. Question number 88. Which of the following provision of CPC 1908 deals with the institution of suits? The right option is option C, that is section 26. Question number 89. Defendant shall within dash days from the date of service of summon on him present a written statement of his defense as mentioned in order 8. The right option is option B, that is 30 days. Question number 90. The arbitral tribunal shall not be bound by a dash in the determination of rules of procedure. The right answer is option B, option D, both the Code of CPC 1908 and the Indian Evidence Act 1872. So, arbitral tribunal is not bound to follow these rules, the rule of CPC and Indian Evidence Act. They're gonna tackle the case accordingly, like discretionarily. Question number 91. Which of the following section deals with arbitration agreement in Arbitration and Conciliation Act 1996? The right option is option B, that is section 7. Question number 92. Under what circumstances the arbitral proceedings can be terminated? Option we have final arbitral award. Points we have final arbitral award. Second, interim award. Third, where the arbitral tribunal issue an order for the termination. The right option is option A, first and three, that is final arbitral award and where the arbitral tribunal issue an order for the termination. Question number 93. Under section 29 of the Arbitration and Conciliation Act 1996, arbitral proceedings with more than one arbitrator and decision of the arbitral tribunal dash, options that we have, shall be made by all members, shall be made by 2/3 majority of its members, shall be made by the chief arbitrator, shall be made by majority of its member. The right option is option D, that is shall be determined, shall be made by majority of its member. Question number 94. The provision for maintenance pendant light in Hindu Marriage Act 1955 is given in section 24. Option C. Question number 95. A Muslim wife may sue for divorce under the Dissolution of Muslim Marriage Act 1939, section 2, if the husband has been insane for a period of 5 years. 2 years. The right option is option B, that is 2 years. Question number 96. Muslim woman has option to be governed by provision of section 125 to 128 of Criminal Procedure Code 1973, which section of the Muslim Women Protection of Rights on Divorce Act 1986 deals with it? The right option is option A, that is section 5. Question number 97. Which of the following is not a ground of void marriage under section 11 of Hindu Marriage Act? The right option is option D, that is child marriage. Wherever it is punishable but it is not void. Okay, so these are bigamy is void, degrees of prohibited relationship is void, spinner relationship is void, but apart from that a child marriage is not void. Whether child marriage is not void, on place of it, it can be said that it is punishable but not void. Question number 98. Spin the relationship means option B, 3 generation of mother and 5 generation of father. Question number 99. A leading question may be asked in examination in chief, re-examination, cross-examination, or none of these. The right option is option C, that is cross-examination. A leading question may be asked in cross-examination. Question number 100, that is last question. Extrajudicial confession means confessions made either to police or person other than judges and magistrate. Option B, confession made before magistrate. Option C, confession made before judges. Option D, none of these. The right option is option A, that is confessions made either to police or person other than judges and magistrate. So this was option A is the right option of question number 100. And with this we have successfully completed the 17th previous year question paper of AIB. Have a good time. We will pick up um, the another question paper, that is question paper AIB 18. Till then, have a good time. Bye.